Celebrities have the exact same right of publicity as everybody else, but the reality is that most litigated cases involve famous people because their likenesses are more valuable and therefore more likely to be exploited. They also have more financial resources than other people to go to court. In the 2003 case Winter versus DC Comics, two musician brothers took a comic book publisher to court, setting their right of publicity against the First Amendment right of free speech and expression. Johnny and Edgar Winter were well-known musician brothers from Texas with long hair and albino characteristics, and Johnny Winter often wore a tall black stovepipe hat. During the 1990s, DC Comics published a comic book series that introduced two villainous brothers named Johnny and Edgar Autumn. The Autumn brothers were depicted as half-human, half-worm creatures with long hair and albino characteristics, and Johnny Autumn wore a stovepipe hat, just like Johnny Winter. Additionally, one of the volumes featuring the Autumn brothers was called Autumns of Our Discontent, an allusion to the phrase "the winter of our discontent" from Shakespeare's Richard III. The Winter brothers sued DC Comics in a California state court for misappropriating their statutory right of publicity. The trial court entered summary judgment for DC Comics, but the Intermediate Appellate Court reversed, finding genuine issues of fact about whether the comic books were protected expression under the First Amendment. DC Comics appealed to the California Supreme Court.